a probabilistic right because for a whole range of underlying legal aspects. For example, you do not really know what you actually own with a patent portfolio unless you go to court and you actually check what the prior art is and to what extent there's a likelihood that the patent will be invalidated. This is a very interesting aspect of this type of property, where you actually know what you own once you go to court. This differentiates IP from many other aspects of property rights. Another really important aspect is the question of what you actually own when you're trying to do international business. This is why I thought talking about international IP enforcement is a really, really important aspect of any type of IP strategy and any type of assessment of the economic value of patents, and obviously also other forms of intellectual property. Now, what may escape the level of awareness of a whole range of people who are not experts in IP is that we have a kind of like a gap in the international IP system where, thanks to the World Intellectual Property Organization and the genius of Arpad Boksh, who was the Director General at the time, we have a very swift and uncomplicated procedure to file for international IP protection, be it in the area of patents, of trademarks, or design rights. The catch there is still that more members need to join, but overall a system has been established that allows to obtain IP protection globally at a in a relatively uncomplicated way, while still respecting national sovereignty. Now, that only hits half the point. The other issue is really, well, once you own your IP, how do you enforce it? What do you do in case of infringement? What do you do if you're at the same time observing infringement in a multiple of jurisdictions? There is no international organization that allows to resolve that problem. This is not to say that WIPO hasn't taken an interest in that and has made that clear at the range of very high-level international meetings, but for the time being it remains an unresolved matter. There have been patches of efforts to resolve the questions, such as like the WIPO Mediation Arbitration Board for domain names. Now at the European level we have a new invention called the Unified Patent Code. But that's a European reply. It's not an international or global reply. So this was the question that I was intrigued with. So I asked William Kirtley, who is not into IP, but who is really into international mediation arbitration, what his toolkit of expertise can do to help get an understanding of what to do about it. William has an amazing background. He has been to some of the best schools in the world. He has graduated from Harvard, from Columbia, from the Sorbonne. He has over a decade of experience in the field. He's admitted to the bar in the United States, in Washington and in New York, and he's also a French lawyer and allowed to admit to the bars in Paris. He recently started his own company, helping all sorts of clients with commercial arbitration. I thought that's an excellent background to help us gain an insight. I was really excited to see that for this seminar we got an international interest in the matter. We got replies really from Africa, from Asia, from Latin America, from the United States, and from Europe. I think you can't be more global than that, and it really showed that it is a global question that the IP community is asking itself. So I would now like to pass on the floor to William Kirtley and make him a presenter. And I'm eager to hear what he has to say, and I'm also very eager to hear your questions after his presentation. Thank you.
Thank you, Roya. Now I thought I actually...
No, wait. I haven't changed the presenter yet. 1 second. Can you make sure, William, that your loudspeaker is at the maximum, that we really hear you well?
Yeah, it is. It's at the maximum. Is this okay?
Okay.
let's see, can you see me, or can you see the PowerPoint at the very least? Okay. So, sorry, Roya, just to make sure, can you actually see me, or can you see the PowerPoint?
Both.
Oh, both? Okay, great. As Roya mentioned, my name is William Kirtley, and I'm a partner at the law firm Kirtley in Paris, which is an arbitration boutique specialized in investment arbitration, international mediation, and investment arbitrations, along with state-to-state disputes. We also represent non-state actors such as the former British Protectorate of Land, which was claiming independence from India. Today I'm going to be focusing on the role of international arbitration and mediation in the cross-border enforcement of intellectual property rights. I will start by briefly examining the challenges posed by cross-border enforcement of intellectual property rights before examining the advantages of using arbitration intellectual property owners' rights, prior to examining the advantages and disadvantages of international mediation as a means of dispute settlement with respect to intellectual property rights. Arbitration as a private and confidential procedure is increasingly becoming used to resolve disputes involving intellectual property rights, especially when involving parties from different jurisdictions, so especially for cross-border disputes. Intellectual property disputes have a number of particular characteristics that may be better addressed by arbitration and court litigation, which I'll be going over. Now, one interesting source of disputes on which I will not be focusing, since it is too broad for today's webinar, and we get us somewhat off track, is concerns laws and regulations put into place by states to deprive IP owners of intellectual property rights. And this actually is the first slide, which I understand that you can see. And this shows the growth of investor-state treaty arbitration. Now, this actually is an option for certain investors to use against states with respect to IP rights. And it's a very ripe source for resolving issues involving laws which are negative to IP rights in the future. And it's being used already by companies today, and it has been for the past 4 or 5 years. For instance, Philip Morris is suing Australia for infringing its trademarks with respect to cigarettes in terms of plain packaging laws. And Philip Morris is also suing Uruguay. Now that's a bit cynical, but there are some other uses of investor-state arbitration which are with respect to IP rights. And I myself have been involved in at least one investor-state arbitration dispute concerning pharmaceutical products, where the IP rights, the trademarks, and the copyrights with respect to this product were violated in an Eastern European company, and we were able to seek the redress that the investor wanted with respect to a law which was discriminatory. But I will not be dealing with that, and I will also not be speaking about criminal aspects of the enforcement of property rights, such as counterfeiting, which arbitration is not well suited to deal with, because that is the prerogative of the states. So rather, I'll be focusing my presentation on the more typical civil disputes that can be resolved by international arbitration. Now, the World Intellectual Property Organization's Arbitration Center is leading the charge with respect to international arbitrations and international mediations, although a number of other arbitral institutions are involved, including the ICC and here in Paris, and to a lesser extent the LCIA, to a significant extent also the AAA for domestic disputes in the U.S. and the ICDR international disputes involving the U.S. The ICC today estimates that approximately 10% of approximately 800 annual arbitration disputes involve an IP element. And as you can see, almost every domain name related dispute is resolved via arbitration, which is interesting. And while the WIPO's Arbitration Center has only had 100 arbitrations over time, it has had 15,000 domain name disputes, and the numbers continue to increase. I would assume as the most choice property is bought up and the internet grows and continues to expand. Now, domain names are not, in fact, technically speaking, intellectual property rights, although the issues addressed in them, such as questions of confusing similarity and good faith, have quite a bit of trademark law about them, have certain elements. But they do overlap, and WIPO has created a very swift procedure that only takes about 2 months, which is conducted entirely in an online electronic format, delivering enforceable decisions with respect to these trade names. Hopefully, and this is not in place yet, but for more general arbitration procedures, it will be possible to have such swift procedures with respect to typical disputes involving trademarks, involving patents, etc. It's not quite there, but a number of, I would say, entrepreneurs are actually trying to set up online systems to make this possible. In terms of the current challenges with respect to the enforcement of cross-border enforcement of intellectual property rights before state courts, now the current system, which is the traditional system, which goes before state courts, does have a number of quite basic issues. The primary issue is that IP rights created by national legislation are territorial in nature, and hence rights created by one country or one regional group cannot be easily enforced in the other. So your patent that was filed in the U.S. has no value in Equatorial Guinea. We've been involved in a number of cases there, and I can assure you that it has no value. Consequently, redressing infringement of counterpart patents, copyrights, or trademarks in various countries entails litigation in multiple foreign courts with different judicial systems and judges with varying degrees of experience and qualifications. If you've ever been involved in court proceedings in Belarus, for instance, with respect to intellectual property rights, you might not be impressed by the independence of the judges. And if you've ever been involved in court proceedings in Italy, you might still be waiting for a decision. But moreover, litigating in multiple jurisdictions is very expensive and time-consuming. It also poses the risk of inconsistent results, where the courts of France find one thing, the courts of England and Wales find something else, and the courts of Angola find something completely different. Another aspect which is particularly important in terms of the failings of court-sponsored IP litigation is that even if the IP rights holder is successful, the rights holder does face considerable difficulties in terms of the enforcement of individual court determinations with respect to their IP rights. Now, if the country that issued the judgment and the country where recognition is sought are not parties to what is known as the Hague Convention on Foreign Judgments in Civil and Commercial Matters, then they will not be automatically recognized in another country, and the need for a separate hearing even with respect to the facts of the case, which is time-consuming and is expensive and can lead to inconsistent results, is possible. And unfortunately, this convention with respect to the recognition of foreign awards is useless at an international level because it only has been ratified by 5 countries, which include Albania, Cyprus, Kuwait, the Netherlands, and Portugal. So if you're conducting business outside of those 5 countries, as many individuals are, the convention is fairly useless. Now, of course, the EU has carved out its own separate regime with the Brussels regime, which does allow the enforcement of foreign judgments that are rendered by domestic courts, but that is only applicable to the EU. So it does not help much outside of the European Union, except with respect to Iceland, Norway, and Switzerland, which also are parties. This leads to considerable problems because your court determination required in the U.S. is worthless in other countries. Arbitration helps to get over this hurdle. So now, not without its own complexities, arbitration can frequently offer a better alternative than litigation. First of all, it it offers a single procedure, and through ADR, the parties can agree to resolve in a single procedure a dispute involving intellectual property that is protected in a number of different countries, thereby avoiding what we were discussing, the extensive complexity of multi-jurisdictional litigation and the risk of inconsistent results. And they can do this simply by agreeing with the parties involved in the disputes to resolve their multi-jurisdictional disputes in a single arbitral forum. With a properly drafted arbitration clause or submission agreement, there are no jurisdictional issues because the agreement to arbitrate itself constitutes submission to the jurisdiction of the arbitrators. So you won't have a plethora of jurisdictional requirements that must be looked at a domestic level, and which vary considerably, especially among common law and civil law regimes. There are also no conflict of law issues as well, which can be a real headache for people involved in international disputes. More importantly, well, as importantly, in contrast to court litigation, the parties themselves may select the most appropriate decision makers for their disputes. So Professor Ghafele, for instance, could be chosen as an arbitrator with respect to an Egyptian trademark dispute or patent dispute, rather than the Egyptian judge that recently sentenced hundreds of Egyptians to death, which is potentially a positive thing in certain jurisdictions. And often the jurisdiction often arbitration can also offer a better, I would say a higher quality of justice, simply because many state court systems are overburdened at this time. And the parties who choose an arbitrator to resolve their dispute can satisfy themselves that the arbitrators have the time available to resolve the disputes in an expeditious manner. In addition, with international arbitration, the parties may choose the applicable law, the place, and the language of the proceedings, which have obvious ramifications on the efficiency of justice. And arbitration can, but does not always, result in a faster process. The primary advantage of arbitration is that there is, in terms of speed, is that arbitration agreements, arbitration awards are final and binding. There are not appeals, except for very limited appeals, And if the party would like to do so, it can tailor the arbitration dispute process in such a manner that it ends quite swiftly, primarily through using something which is called expedited arbitration. So in your client in their licensing agreement, you can consider adding an arbitration clause calling for expedited arbitration under the WIPO rules, and this will ensure that the entire process only takes a few months rather than quite a few years, potentially. Arbitration can also be slow, however. The average arbitration takes over a year, so I would recommend including expedited arbitration clauses when possible, except for the most complex disputes involving the largest amount of damages. Arbitration is also a positive in terms of the enforcement of IP rights because of its neutrality. Now, ADR can be neutral to the law, the language, and the institutional culture of the parties, thereby avoiding any home court advantage that one of the parties may enjoy in court-based litigation. Where familiarity with the applicable law and local processes can offer significant strategic advantages. Or in certain countries which are off the beaten path, where we've worked in the past, such as Algeria or Equatorial Guinea, like there can, or at the Ivory Coast, you can have blatant discrimination, unfortunately, on the part of certain judges. Are arbitrators always neutral and impartial? Well, they must be in international arbitration, or else the award that they render can be challenged, because partiality is one of the few grounds on which a court can refuse to enforce an arbitral award. So while you will have the occasional, it's quite rare. It's quite rare that you'll find a non-neutral arbitrator, and if it does happen, their award will be largely meaningless. Finally, arbitration proceedings are confidential to a far greater extent than domestic court litigations, and this allows them to focus on the merits of this dispute without concerns about its public impact or any harm to their reputation of dealing with the dispute. In terms of, I already mentioned the finality of the awards. There's not a lengthy appeal process, so once you have your award, you do know what your right is. And in terms of the enforceability of awards, which is a huge advantage, as you saw previously, I mentioned that there were only 5 countries where foreign court awards could be enforced in other countries, meaning that you have to make multiple applications with respect to the same IP right before most domestic courts, the domestic courts of most countries. Whereas with the New York Convention, as you can see on the map in front of you, I hope the map is showing, there are 150 countries today where international arbitration awards can be enforced. So it's under the New York Convention. The latest of which was the Democratic Republic of Congo, which is actually not shown on this list, but we cover a bit more of the world. But we're really getting to a point where the enforcement of international arbitration awards related to IP rights is almost at the point of universality, of being universal. So, well, that sounds great. Why isn't every cross-border dispute involving IP rights settled by international arbitration? Now, unfortunately, there are 2 major roadblocks to using international arbitration with respect to IP rights. First, what I would call the hostility of states for encroaching on what they consider to be their territory, and the notion of what is known as arbitrability has posed the question. Traditionally, arbitrability, or the question of whether the subject matter of dispute may be resolved through arbitration, arose in relation to arbitration of certain IP disputes. Now, as IP rights, such as patents, are granted by national authorities, it was argued that disputes regarding such rights must be resolved by a public body within the national system. This was the position of many state courts until the past couple of decades, when things have evolved more swiftly in common law countries, I would say, than in civil law countries, but they are evolving. And now the common law courts have taken for the most part, taken the stance that any right which a party can dispose by way of a settlement should, in principle, also be capable of being settled by an arbitration, of being the subject of an arbitration, since, like settlement, arbitration is based on party agreement. So as a consequence of the consensual nature of arbitration, any award rendered will be binding only on the party involved, and will not and although it will not involve bind third parties, it is possible under most common law regimes. And in the United States, Canada, Australia, and the United Kingdom, and a number of African common law jurisdictions, the arbitration of IP issues, including patent validity, is possible, at least when raised defensively to a claim of infringement. However, in other countries, such as France, where I live, and China, the arbitration of infringement issues is possible, but not always those of the questions of validity, which French courts and Chinese courts consider to be the state's prerogative. So unfortunately, this does block some of the, potentially blocks the usefulness of arbitration before, with regard to claims before certain state courts. And actually, this can be should also be remembered in terms of enforcement, because even if your dispute, for instance, was settled in the United Kingdom by arbitration, but you needed to enforce the arbitration award in China, if it did concern the validity, the issue of the validity of a patent, it should be recalled that this could potentially pose problems, and so you might have a hard time obtaining compensation for the for the award that was rendered in your favor. Now there are usually ways of getting around this, but it really depends. It's really on a case-by-case basis. Now the more significant issue with respect to using arbitration to enforce IP rights, in my opinion, is that arbitration is necessarily based on consent. It's necessarily based on a pre-existing contractual relationship between the parties to a cross-border dispute, and unless you put it already into your initial licensing agreement or a franchise agreement or other IP agreement, it can be very difficult to convince another party to sign an arbitration agreement once a dispute has arisen, especially if the other party has violated your rights and knows it, as is frequently the case. So moreover, if the parties have unequal resources and a dispute has arisen, the one with greater resources will typically find a tactical advantage in court litigation and in multiple litigations, since they can outspend the smaller IP right holder in terms of the costs of multiple disputes spreading throughout multiple jurisdictions, which can be enormous. So if you're taking a swing at Google in 10 jurisdictions, you would much rather do this before an arbitration tribunal, in my opinion. But you would want to put this in your initial contract with Google if you could convince them to do this. There are some other reasons why you would not want to use arbitration to settle civil disputes. Unlike like civil law disputes, individual disputes do not create a binding precedent. So if your point is to establish a principle using common law courts, arbitration is useless. So you will never have a Sony Corps versus of America versus Universal City Studios when the Supreme Court of the U.S. ruled the making of individual copies of complete television shows for the purpose of time shifting, the famous Betamax case, does not constitute copyright infringement because there is no precedent. And unless the parties have been very clear and specific in their agreement to arbitrate, discovery will be far more limited in arbitration. Now, I personally consider that to be a good thing because a considerable amount of litigation, especially in the U.S., and a significant amount of litigation budget is consumed by discovery, and you will have less of that in international arbitration. But if you are involved in a dispute where you suspect or even you're certain that your opponent did something but you can't prove it, obviously discovery can be useful. Now you can get expanded discovery, but it's the nature of arbitration. It has a significant civil law influence, and so discovery is frowned upon to a certain extent. Now, how do you ensure that your IPRs can be enforced by arbitration? As I mentioned, you should put it in your contracts. You should put it in your licensing agreements, especially those entered into by parties from different jurisdictions. You can put a clause in your patent, know-how, and trademark licenses, franchises, computer contracts, multimedia contracts, distribution contracts, joint ventures, research and development contracts, technology-sensitive employment contracts, mergers and acquisitions, sports marketing agreements, etc. There are some things you have to be careful about when you are drafting arbitration clauses, which should be avoided. Something which some companies such as Microsoft do, which I think is a very bad idea, is to try to divide potential disputes into non-arbitrable IP issues, such as the validity of patents, and arbitrable commercial ones. Now, this sounds clever to do because you can avoid the issues that I mentioned previously with respect to states like France and China, to carve out certain classes of IP disputes from the arbitration clause. But unfortunately, this creates a procedural nightmare where you have multiple forum selection agreements and arbitration agreements that determine jurisdiction, and it can lead to a huge mess in terms of establishing the proper jurisdiction of the court for a case. So another issue another thing which in-house legal counsel does far too often for my own personal case is to include step clauses where you have multiple tiers of dispute resolution. For instance, you start by discussing settlement. It's in the contract, followed by mediation, which we are going to turn to a bit later, and followed by arbitration for unpaid license fees. Now the problem is that each of these steps creates conditioned precedents which allows opposing counsel, the opposing party, to delay the proceedings and multiply the number of objections with respect to the jurisdiction of the arbitration tribunal, because they will argue that a conditioned precedent has not been satisfied, and that the timing, for instance, the 3 months of dispute resolution that was provided for was not in fact respected based on the wording of the clause. I've seen this happen dozens of times, and it's best to avoid step clauses and just to rely on model arbitration agreements such as those prepared by WIPO. And once again, you should keep in mind there will be less discovery. Now, if you want to obtain access to arbitration, which can be much swifter, as I mentioned, and which has a considerable number of advantages, you can also do so after a dispute has arisen by way of a submission agreement, as it's known. Now, a submission agreement is just an arbitration agreement. The only issue with using a submission agreement is that you do have to get the party to agree to sign it. And this can be very hard to do. Now, something which is a clever way of, I would say, bringing in arbitration as a dispute resolution mechanism through the back door is including it on websites. Pretty much anything which is made available by the web, any type of agreement which is entered into by the web can be subject to international arbitration. So if you register on a website like Spotify, streaming music, you are agreeing to arbitration. There was recently a bit of a scandal because it's kind of funny. General Mills was forcing everyone into binding arbitration if they downloaded a coupon or subscribed to an online newsletter or entered a sweepstake. And individuals were not aware that they were entering into the rights, and there were some debates about whether you clicked like on their web page, whether or not you were entering into binding arbitration. And although this can be a good thing, if you are a consumer of a certain product, and you wanted to be part of a class action, for instance, going to arbitration could be would not be as helpful for you. In terms of mediation, which is the final topic I will be dealing with before we discuss this a bit more, the truth is that mediation is far more frequently used simply because it is a swifter and less expensive procedurally than binding arbitration. You can see, for instance, and on the screen, I hope, if this is working, you can see that 95% of disputes, intellectual property disputes that take place in Japan, for instance, this is our statistics from the Japan Intellectual Property Arbitration Center, have been resolved by mediation rather than arbitration. Now, mediation, as you may know, because it is better known than arbitration, is a flexible settlement technique conducted privately and typically confidentiality, almost always, in which a mediator acts as a neutral facilitator to help the parties try to arrive at a negotiated settlement of their dispute. In essence, mediation is someone helping you to negotiate with respect to your IP rights, because you were unable to negotiate with the other party. It was too difficult. And this can often happen when there are highly different cultures. There are different negotiation cultures involved. Like the French negotiation culture, for instance, is very different than the I would say than the American one, even, which is far more direct, I would say. And obviously, if you're negotiating an agreement with a Chinese company, the negotiation style can be difficult as well. And if a dispute has arisen as well, it can be hard to find. An easy resolution to that matter without using a mediator who is trained in assisting with finding such a settlement. But in the end, mediation is really just negotiation seeking to find a win-win solution for both of the parties. It does involve compromise, and so if one of the parties is if the party does not want to compromise because they consider that they're 100% justified with respect to their IP right claim, mediation might be a waste of time. And also, if the other party is acting in bad faith, it is a waste of time. I mean, the other party might attend to make it look like they were participating in the process, but there's nothing you can do if the party does not want to, even if you've signed an agreement calling for mediation, and even if the opposing party does attend with respect to a license agreement, there's nothing you can do to force them to accept a decision. And the only way that mediation becomes final and binding is if the parties enter into an agreement with respect to the settlement of the dispute. And then, like any contract, it does become final and binding. But you don't have the, but it would be enforced like any other contract rather than relying upon the New York Convention, which is available in arbitration and allows you to go to 150 different companies. But at the same time, I do recommend it because 9 times out of 10, rather than going through an arbitration, which can take certain companies well over a year, the average duration of an arbitration at the ICC is 18 months. It is possible, and the average cost of an arbitration before the LCIA and the ICC and the ICBR for large international disputes is well in excess of $1 million euros. So there are good reasons in terms of time and cost to attempt mediation, even if it does not have the same binding precedent. Now that more or less ends what I would like to say about the dispute, but I did want to mention that first of all, mediation is typically used in conjunction with arbitration. Frequently, the best way to ensure that a party does take part in mediation is to have a stick, and the stick is basically binding arbitration. And the fact that the other party does know that they will have to go to arbitration, they will have to spend a year and a half settling the dispute, and they will have to spend a considerable amount of money defending the dispute, and a lot of time and energy if they're unwilling to resolve it via mediation. And frequently the parties will commence an arbitration, as you can see, with respect to this document concerning WIPO arbitration disputes. And they will start with arbitration, they will move to mediation. If they settle it, very well. The case is over, and if it doesn't settle, they go back to arbitration until the end, so that they will have resolution to their international dispute. Oh, and just one other thing I wanted to mention, I can't stress how important it is, especially for disputes which are not for an amount. Any dispute involving an amount that is less than, I would say, approximately $100,000, I would highly recommend using what is known as expedited arbitration. It's simply swift arbitration. And you can see the WIPO has actually introduced arbitration rules, expedited arbitration rules with respect to IP rights, where the entire proceeding only takes 2 months. And 2 months to resolve an intellectual property-related dispute is obviously of considerable interest as compared to going before a state court. So that ends the initial part of my presentation, but I did want to open the floor to questions that any of you might have with respect to this matter. Let me see if I can get back on to the main presentation, but I did want to open up and see, do you have any questions with respect to IP-related international arbitration disputes?
Well, thank you very much for this presentation, William. Technically speaking, I've tried to unmute people, but I think if you want to ask, but those people who muted themselves, I cannot unmute them, so you would have to unmute yourself to ask a question. I can't force people to be unmuted. In case for any reason you don't figure out how to unmute yourself, I guess you could just type in a question.
Yes, if I can find...
you could type in a question in the slide board.
Okay, I've got it back. Okay, great.
Just that, like, we had already one question that was asked during your presentation.
I'm sorry, I didn't
which was asked by Chuck Meyer, who said, like, you may get to this, but aren't there still some jurisdictions like Italy that preclude arbitration of IP disputes?
Yes, that was the arbitrability question, and as I mentioned, it's more of an issue in civil law countries such as France, where I currently practice, because they do consider that it is the state's right to determine some of these issues. Usually, it depends on what the precise claim, IP claim involves. If it's solely a claim relating to the infringement of an IP right, you usually can deal with it by arbitration. But once again, not a question of the validity of the IP right in countries like France, Italy, China. I think that Brazil has taken that stance as well in terms of patents, but I'd have to double check about that. But that is an issue. That's the second biggest issue, along with consent for using international arbitration to resolve disputes. And unfortunately, we have not found a perfect solution to that yet, although it is definitely heading in the direction of increased use of international arbitration.
Are there further questions? Jesus, I tried. That's what I wanted to get shown. Any further questions? If you unmute yourself, you can just speak. If for any reason you don't figure out this unmuting, you can type your question in the chat board, which is here.
What about you, Roya? I know we've dealt with some international, some IP-related disputes.
Well, what I think about is that this is one of the questions where we get to the core of globalization, where we get to the core of an international economic order which has to deal with a judicial structure which reflects a Westphalian state order. So we're really here stuck with a business world that has moved much, much faster than the law. At the time when many of the treaties that regulate the international IP system were designed in the 19th century, such as the Berne Convention, etc., it was absolutely fine to have territorially limited rights. That was the world of the 19th century. I mean, you had Great Britain, you had France, you had Germany, you had all these European countries, and they felt like, well, we are our country and we want our sovereignty and we want our property rights protected in our territory, territory. And maybe, yes, you still had the colonies. And if you look, for example, at the Imperial Copyright Act of 1911 of Great Britain, it's exactly the same Copyright Act in Singapore and in Australia and in Canada. And that's quite amusing. But nobody could foresee in the 19th century that we would have such major breakthroughs in technology, in business strategy, that system just wouldn't work anymore. And that's where we are stuck at the moment. And we have some half-hearted realized ideas like the TRIPS agreement or a system for WIPO for filing. But all of this makes the whole question, what is a patent actually worth, very questionable. So that comes down to a pretty core question, what I said at the beginning, what Thies has pointed out, that patents are probabilistic property rights. In theory, you own something, but what you really own, you will only know once you try to enforce your rights. And that is still, if we're looking at issues such as like developing financial markets on the basis of IP, trading patents on a stock exchange, or developing all sorts of investment funds on the basis of IP, as long as we haven't figured out what we're actually trying to turn into an investment product from a legal point of view, all of this is a bit bumpy. And I on the other side, I also think this is a major business opportunity, and that is also probably why WIPO is so keen in getting involved in this.
I think WIPO, has recognized that this is important, and other arbitration institutions such as the ICC have become very involved. They've been resolving domain name disputes as well, and it is just a gap. States are unable to agree amongst themselves on a convention that they have signed in the past. It would allow for the effective enforcement of domestic decisions with respect to IP rights. They can't agree. They can't agree amongst themselves on a convention. And so arbitration really exists to fill the gaps where there is a jurisdictional void. And you'll see in a number of domestic court systems, such as Australia, arbitration was favored quite a bit for everything involving domestic, not everything, quite a few disputes involving property, for instance, were resolved by arbitration in domestic Australian procedures, but that's been replaced as Australian courts have become more sophisticated. Mechanism to deal with this. So arbitration is a private solution that fills the gap. And it's beginning to do so with respect to IP rights as well.
There was another question from Sarah Pike, who asks, what issues arise regarding costs awards when multiple jurisdictions are involved? Are the costs awarded based on the agreed arbitration jurisdiction?
That's a good question. And unfortunately, I would say that 20 years ago, when it really depends on the legal background of the arbitrator, I'm afraid to say it. So if you've chosen a president of the arbitral tribunal who is British, you will have cost awards where costs follow the event. If you choose a French arbitrator who's passed away, but I previously worked at his firm, he would typically force both parties to, he would not have costs follow the event, regardless of the seat of arbitration and regardless of the law of the dispute. So it is, this does underscore the extent to which the legal culture is important, because there are no hard and fast rules. Although arbitrators truly are entitled to award costs at the end of an arbitration, but they won't. They won't if they come from a legal culture where this is not done. I do.
I think the other last point, which comes to my mind after I listen to you is it doesn't fix the problem of piracy in any way.
Piracy? Well, piracy, no. I mean, you need the coercitive force of state courts to I mean, you need the police to intervene. With respect to piracy, illegal downloading, etc., you need the FBI, you need the, and arbitration can't deal with that. It's limited to the sphere of civil dispute. You know, unless, you know, you could, for instance, it's not inconceivable that some form of agreement, including an arbitration clause, could be entered into with the major providers of internet access to China. That include an arbitration clause, potentially, and then you would have access to arbitration. But until that day, there's little that can be done about individuals violating copyrights with respect to arbitration. But if it's done on a large scale and spearheaded by any organization which has a reputation to defend, arbitration can be used. So arbitration would be possible, for instance, against, you know, if Napster existed today and had entered into any contract, you could potentially have arbitration with Napster to stop the widespread piracy, but you cannot go against the individual downloader.
Great. Are there any further questions from the audience? It's now or never.
And I just wanted to say, and one of the things which I consider to be extremely novel about the world today, and I don't know if you mentioned at the very beginning, it's the number of investor-state disputes. It's that actually the role of the state and the power of the state has diminished to such a significant extent, and really there has been a rebalancing away from states' powers to the international business community, that it is possible to challenge actual laws involving IP rights by large and powerful investors. And I find that fascinating. I mean, this has only happened in the past 5 years, but it works. And you know, you can. I don't think Philip Morris will win. You know, their trademark has been infringed by the plain packaging laws, because there are exceptions to states are allowed to take measures with respect to the public health of the population. But it's a fascinating topic because the possibilities are quite large for states that, like China. I mean, China, there are widespread abuses in terms of copyright violations, and I'm surprised that investors, to the best of my knowledge, I've not looked at that today, have not started arbitration against China as a country. But anyway, I digress.
Great. Well, thank you very, very much for this presentation, William.
Well, thank you, Roya.
I really think this whole thing about like the relevance of the nation state, are we in an international economics order or are we in a borderless world, all of this is really, really core to this question, even though that comes from a different discipline of research. This was a really, really interesting talk. I learned a lot. As you can see from the interest and the request we get for attending this webinar, we didn't have enough seats to accommodate everyone. It really shows that this was a great talk. Thank you very, very, very much for your time, and my best wishes to Paris. Thank you.
Thank you very much, Roya. It was a pleasure.
Bye.
Have a great afternoon. We'll speak to you soon.
You too. Bye.